human being. While many may argue one who commits such a crime deserves to die, it is hypocritical for a government to perform the same action it intends to punish. The goal of a government should be to embody the virtues of its society, such as the respect for human dignity and the sanctity of life, rather than incorporating the vices of some of its lowliest citizens. As stated by philosopher Stephen Nathanson, by abolishing the death penalty, governments would express and reaffirm their belief in the inalienable, unforfeitable core of human dignity. Supreme Court Justice William Brennan expressed similar sentiments when he stated that the death penalty treats members of the human race as non-humans, as objects to be toyed with and discarded, and is uniquely degrading to human dignity. It is necessary that governments draw a line in their dealing with their citizens and reaffirm the value most important to the functioning of society, a respect for human life. Furthermore, the application of the death penalty in the United States has shown to be fraught with error. Since 1973, 138 individuals were released from death row after evidence proved their innocence, an error rate of about 1%. 17 of these individuals were released after DNA evidence proved their innocence, but not before they spent a total of 209 years in prison. The government can never compensate these individuals for the wasted years spent in prison or the anxiety they felt facing the death penalty. In addition, these statistics suggest that many innocent people have also been put to death. With the number of wrongful convictions as high as 1%, there are likely to be more that were not exonerated. It is impossible to tell how many innocent people have been put to death, though, since a court will usually not hear claims of innocence after the death penalty has been administered. However, research has uncovered several likely claims of innocence, such as that of Ruben Cantu, who was executed in Texas at the age of 25 after spending 8 years on death row for a crime he probably didn't commit. In dealing with a procedure as irrevocable and final as the death penalty, it is outrageous that a government would continue its use when there is a likelihood it could be administered in error. The possibility that the death penalty could deprive an innocent person of everything is too much a risk to take and cannot be outweighed by punishing others that actually did commit their crime, especially when other forms of punishment do exist. A government's respect for its citizens should translate into protecting them from a wrongful application of law as final and irreversible as the death penalty. In conclusion, a respect for human dignity and the sanctity of life should be enough for a government to discontinue use of the death penalty. A government does not provide its citizens with basic moral rights and therefore should not be able to take them away. In addition, the likelihood of an error resulting in an innocent person being put to death makes the governmental use of the death penalty immoral. In no situation is it ever morally permissible for a government to deny an innocent citizen their life. Therefore, the United States should join the 95 other countries in the world that have abolished the death penalty and reaffirm the value of human life and their intolerance of serious error. Thank you.
Punishment is justified within the legal system. When the immense question of taking a human life is at stake, constitutional and moral justice require that trial procedures and sentencing be unquestionably fair. The Eighth Amendment protects individuals from cruel and unusual punishment, and the Equal Protection Clause of the 14th Amendment protects individuals from prejudice within the legal system. While the law is seen sometimes as an instrument of justice, this justice should not come at the expense of other basic human rights everyone is guaranteed. Capital punishment crosses these boundaries, violating the rights our legal system was built on. The death sentence can be labeled cruel and unusual, not only in the moral sense, but also in the legal sense, because the strategy of choosing which lives to end is arbitrary. In the Furman versus Georgia case of 1972, Justice Stewart cited the inconsistency and erratic nature of choosing who to die as a direct violation of individuals' rights. Justice Douglas from the same case wrote that prejudice enters the decisions, especially if the accused is poor and despised, lacking political clout, or a member of an unpopular minority. Because the death penalty is often applied for legally irrelevant reasons, the sentencing is unfair in the eyes of the law. Less than 2% of the defendants eligible to receive the death penalty actually receive the execution sentence. And the logic that these cases are simply the most heinous cannot be applied, because while some have been convicted and sentenced based solely on conspiracy to murder, for example, defendant Gary Ridgway admitted to murdering 48 victims but received a life sentence in exchange for cooperation. Racial trends are also evident in the data collected by the Death Penalty Information Center. Over 75% of the cases where execution was sentenced, the victims were white. Though nationally, less than 50% of all of the murder victims are white. Texas, geographic inconsistencies are also noticeable within the data. In Texas, we have a murder rate of 5.4% and 464 executions since 1976, while Maryland has a murder rate of 7.7 and has had 5 executions in the same time. Another aspect of the law that I think is vital when deciding to put someone to death is giving them competent counsel. The poor legal quality of counsel in murder cases often correlates with the low socioeconomic status of the defendants. In a study done by the Chicago Tribune, it was found that attorneys who were sanctioned for unethical or criminal conduct represented 12% of the defendants who were later sentenced to death. So even though the law guarantees everyone an attorney, it does not guarantee a competent one, a detail I think is vital when deciding to end someone's life. These facts prove that the legislation regarding the death sentence does not provide equality among defendants. It is impossible to create criteria that eradicate all prejudice from a jury's decision, and unpredictable human emotions should not have the power to take a human life legally. Furthermore, if you look at capital punishment based on efficiency, the costs greatly exceed the benefits. Extensive studies done by the Death Penalty Information Center show that states with the penalty have a 42% higher death rate or murder rate than states without the penalty. And in Texas, the average death penalty case costs $2.3 million, 3 times what it would cost to imprison the same defendant in a maximum security center for life. So even ignoring the moral and legal issues, the death penalty, when looked at from a purely economic standpoint, doesn't warrant justification. Taking someone's life is a monumental decision, and the inconsistency and fickleness of the sentencing, combined with its ineffectiveness and high cost, leaves no other option but to consider the penalty a violation of basic rights and detrimental to society. Thank you.
Although my opposition makes some good points, there are some discrepancies in their arguments that I would like to address. Regarding the argument that it is wrong for the government to utilize the death penalty because it is degrading to the subject, lacks respect for human life, could be classified as cruel and unusual, and violates principles which the justice system is based on, we must take into account the kind of people that the death penalty deals with before deciding on a set of moral standards with which they should be treated. The typical candidate for death row is likely a past criminal who committed an act of gruesome, evil murder. It is fairly obvious that a murderer of this sort lacks respect for human life. He committed a murder which was evil, disrespectful, and degrading to another human being. More specifically, he committed an act which was both cruel and unusual. It is not like the murderer killed his victim with a painless lethal injection, which is generally how he would be executed if found guilty for a high degree of murder. I feel that when a person commits an act in which he deprives another of his or her life or dignity through aggravated murder, the murderer should lose his right to life and dignity, thereby entitling the government to administer capital punishment, whether it is cruel and unusual or not. Capital punishment in past years can be classified as barbaric, cruel, and inhumane, but in recent years, crucifixion, burning, and decapitation have been replaced by lethal injection that inflicts minimal pain on the executed person. Considering the fact that a capital murderer committed an evil, gruesome act upon another person, I do not feel that execution by lethal injection is immoral, simply because the murderer is being treated with higher moral standards than he treated his victim. Addressing the argument that the death penalty is fraught with error, that innocent people have been condemned to die, we must examine the true cases of wrongful guilt, the true causes of wrongful guilt in the legal system. If a suspect is found guilty of capital murder, put on death row, put to death, and then found to be innocent after death, the error in judgment is completely independent of capital punishment. While the suspect died because of the death penalty, he did not die unjustly because of the death penalty, but rather because of the failure of the legal system to administer proper justice. As I discussed earlier, the legal system must promote justice through punishing the guilty, protecting the innocent, but also by issuing punishment correctly. Similar situations frequently occur with lesser crimes. For example, a suspect convicted of robbing a bank, sentenced to 12 years in prison, and found innocent after serving 8 years is in a similar situation, with the suspect being wrongfully punished and suffering for another's crimes. I understand the opposition's intentions.